I hope you've had a chance to get your coffee because title opinions can be kind of boring. No matter which side you're on, they're kind of a necessary evil, but they're not the most exciting things. In fact, one of my sons asked me what I was speaking on, and I told him, and he said, well, maybe you ought to have Dad sitting in the audience, and when he starts yawning, he should put his hand up in the air, and it'll be kind of your yawn meter. And I said, well, that's fine, but what do I do when he puts his hand up? I still have to tell, I still have to talk about the same stuff. So, if you guys are going to yawn, don't put your hands up. So, the other thing he told me to do was to start by telling a lawyer joke. And I said, no, I don't really like lawyer jokes. I don't like to be the butts of them. And the other thing is that, lawyers don't think they're funny and nobody else thinks they're jokes. So we won't go that route. So anyhow, with that, I need to tell you that the views expressed in this presentation are not intended to be legal advice. They are solely my views, and these views may not represent the position or the opinion of my employer or any organization that I might be affiliated with. So basically, it's kind of what I think. So, okay. My presentation is going to be a general discussion of how I deal with title attorneys and what I like to see included in a title opinion. So hopefully it'll be relevant for both title attorneys, for the land professionals in the group, as well as those of you who are helping our mineral owners cure their title opinions or cure their title requirements. Once an oil and gas company secures its leases, but prior to drilling the well, we engage a title attorney to prepare either a drilling title opinion or a division order title opinion. A drilling title opinion will determine who owns the leases covering the mineral interests in the lands, encompassing our spacing unit, and it will tell us what the irregularities, defects, or encumbrances affecting those interests are. A division order title opinion will go one step further, and it will include the division of interest, listing all the royalty owners, all the working interest owners, the overriding interest owners, and then it'll tell us their individual share of production. Now, typically in the Bakken, we have been ordering division order title opinions because most of the wells are successfully producing, and we're going to need that division of interest sooner than later. I'd like to share some general observations before I get into what I like to see in a title opinion, and this perhaps is more for the in-house attorney or perhaps the land professional. When you request your opinions, know that first and foremost, you're the client, and the title attorney wants to please you. They want to give you a product that you can use and that you understand. So make sure you talk to your title attorney about those things that you'd like to see, about how you'd like requirements to be written. Get to know your attorney's style. Get to know whether they are someone who will want to put everything in the opinion from statutes to the relevant law to they just maybe go overboard. Then there's those who will determine that insignificant things don't need to be reported. You need to know what they consider an insignificant thing because maybe it's something that's important to your company. But there are those you might have to rein in and say, I don't need you to copy me the statutes. I don't need you to cite the case law all the time. Maybe at first, maybe when you enter a certain prospect, you want to have some of that information, but not on a continual basis so that you end up with very thick title opinions that you've got to go through each time because you don't know if they've added something else to it. Plan ahead. Try to give your title attorney adequate time and information to prepare the opinion you need. Make sure that they're comfortable with the information that you're giving them. Realize you're not their only client and they're not there 24/7 to answer every question you have. They have a life too. So, let's try and give them a little credit. And sometimes you have to remind them that they have a life and that they shouldn't be working. If it's something that doesn't have priority, by all means tell them so that they don't spend that weekend there. They'll love you for it later. There's always going to be those rush jobs. And if you communicate with your title attorney, sometimes they can help you, sometimes they can't. But most times they are going to try. level with them. If you missed the deadline, or you, for some reason, didn't know that this well was going to come up, we have situations where our subsurface team comes in and says, oh yeah, we'd like to drill this well, can you get us an opinion in 2 weeks? Well, if I have the abstracts, maybe if they're not, 4 bankers box fulls, maybe I can do it. But, talk to your attorney, see what they can do. If they want to try and help you, if they think it's going to cut close, just have them call you with the major issues that they're seeing as they develop the opinion. Most of your title attorneys will do that anyhow, but especially when you're in a rush situation, you want to have them calling you when they see holes in your leasehold or major issues that are going to come up. You don't want to get caught that last day before they drill finding out that information. Realize that title is not always what it seems. Sometimes you'll get an abstract that's only a couple inches thick and you'll think, oh, title attorney can do this in a couple weeks. Well, those couple inches could be chock full of the worst assignments and missing leases, things like that. So just be open to knowing that sometimes it just isn't what it seems. Sometimes you'll end up abstracts with 3 or 4 bankers box full of abstracts, and you end up with a 1,400-page opinion and 300 requirements, and I guess it's job security. But the other thing is, I don't like to give out the name of my title attorney to my mineral owners. First of all, I don't want them calling my title attorney and creating a bill that my company is going to have to pay. Second of all, I don't want them calling my title attorney and harassing them about something. I would prefer that the mineral owner call me, or the working interest owner call me, or have their attorney call me, and we will try to resolve the issue. And if we need to go back to that title attorney, I'll be the one who does it, and I will talk to them about if there's a missing document or if there's a incorrect interpretation or whatever, and then if a new opinion has to be ordered, that'll be my call. So I just don't think you should give out that information. Over my years at Marathon, I've developed a basic list of what I like to see included in a title opinion. So I'll just kind of list them and tell you some of the reasons why. Of course, we start with the description. The description of the lands covered by the opinion should be stated front and center. Make sure it's correct. Make sure that you understand any limitations it might identify, whether it's not a complete spacing unit in terms of 1,280 acres or 640 acres, or if there's just a few acres short, that kind of thing. Make sure you understand it, because that obviously comes to play when you're going to calculate interest. Make sure you understand if there's depth formation limitations. We're starting to see some of those things in our assignments, and you need to know, front and center, first thing, what you're dealing with. Make sure you understand what materials have been examined by your title attorney. Was it a prior opinion? Was it just abstracts? Was it other documents? Maybe they checked ENDRIN. Maybe they used some documents that you sent them that haven't been recorded yet or weren't going to be recorded. But just make sure you understand what's been examined. And if you see gaps in the abstracts or anything else, make sure you call that title attorney right away, because that may be an indication that the opinion isn't complete. Patent information. Some attorneys will set out the patent information for each tract. Some will only speak to it if there's a problem. Personally, I want to see it only if it's a problem. I want to be able to assume that my title attorney has checked that and we're good to go. Ownership. I'd like to see the current surface ownership by tract. This is used to identify from whom we need to secure our surface use agreement, and then any road access agreements and that type of thing. If there's surface issues on any part of the unit outside of my well pad site, we normally will send that to the the surface owner as a courtesy, just to say, hey, this was uncovered in our title search. Maybe you want to discuss it with your attorney and see if you want to do anything. I'm not making a requirement of you because your surface doesn't affect my well pad, but hey, we found this. You might want to address it. Next, I want to see a complete mineral ownership for the spacing unit by tract and by unit. I want to see what percentages of ownership each individual has, including how many mineral acres that calculates out to and the corresponding lease that holds that acreage. I want to see the leasehold ownership of each of the working interest partners by tract and by unit, and I want to see which lease coordinates, or the corresponding lease to that interest as well. I want to see what overriding royalties attach to each of those leases. So in essence, I want to see what the gross working interests of each of my partners are in the well as the burdens that are going to be assessed to those leases and to those partners. I don't want to see ownership for anything other than oil and gas in the Bakken play. I don't want to pay for other minerals or coal bed methane or that kind of thing. I guess that's something to discuss with your title attorney too, and just make them understand what it is you're looking for. I want the opinion to include an oil and gas lease table that sets out all of the effective oil and gas leases for that unit. I want to have the full names and addresses of the lessors and the lessees. You might prefer to have that information in your division of interest table or maybe in both places, but that's something you can talk to your title attorney about to see what's easiest for them. I want to have that table include the royalty rate of each lease. I want to see the royalty clause verbatim because my division order analysts need that information to determine and correctly assign costs for our gas sales. I want to see the term of the lease and the date it was signed. I want to see the interest owned and leased by the lessor. I want that description to include all the lands leased, not just those in the spacing unit. I need to have that information because when it comes time to do our affidavit of production and record it against those lands, that way we're holding all the lands in production by that lease. I want to see the recording information, including the date of recording. I want to know that the lease has a pooling clause that covers the spacing unit. So if my title attorney simply says, yes, I know that he's answering that specific question. I want to know if there are any delay rentals and when they're due. I want to know what the shut-in clause provides, and I want to know if there's any other special lease provisions that I should specifically be aware of or take note of. If there's tribal or allotted leases, I need to know whether we have the required percentage of consents and whether the BIA has approved that lease. I need to know if any of those leases have been extended or ratified. In addition to the lease table, I want the opinion to include a list of all of the assignments of those oil and gas leases and then the leases that those assignments specifically affect. I need to see the assignments of overriding royalties and the leases that those assignments affect. Within those tables, again, I need to have the full names and addresses of the working interest owners and the overriding royalty interest owners. And again, maybe that's something that can be put in the division of interest table, but somewhere in that opinion, I need those names and addresses. I want to see a list of the easements affecting this particular spacing unit so I can make sure that our operations haven't violated anyone else's rights. I need to know what encumbrances affect the spacing unit and whether it be the surface interest or the mineral interest. And I need to know if those mortgages given by our mineral owners, whether it be a mineral owner or a working interest owner, whether that mortgage allows me to pay the owner directly, or if an assignment of production means I've got to put that financial institution's name on their check. There's a lot of those mortgages that have provisions in that will allow us to pay the owner as long as there's no default, and I need to know that. But if I'm going to have to put the financial institution's name on the check, I also need to know the full name of the institution and the address. And again, those are all things that I can perhaps look up, but you guys have them in front of you, and so I would prefer that you just put it in the opinion. I need to know what judgments and liens of any kind exist, whether they be child support, whether they be income tax liens, because when it comes time to pay those owners, I may need to suspend until those liens are taken care of. I need to know if the real property taxes are paid specifically for the well site. I need to see a list of any of the unreleased oil and gas leases so I can determine if there are any existing leases that are held by production that are going to impact my spacing unit. Finally, the division of interest needs to show me the full names and addresses of all the owners that will receive revenue for the unit from the production of this particular well. If there's been any conveyances since the leases were taken of some of those owners, I expect that the attorney will catch those address changes and then, have put them in there for us. The ownership of all the owners, when added together, needs to equal 1. And yes, you really need to make it equal 1. I have gotten a division of interest that did not equal 1, and yes, that did prompt a call to the title attorney. They were working on it. So I want to see the full calculation for each of the owners in that well, their net revenue interest in that well, so that I can explain it to an owner when they call. I figure if the title attorney has done all the work and has gathered all the components that they need to make that calculation, I might as well have them put it down or, on paper so that if somebody calls, I don't have to search through the opinion, looking for the royalty rate, looking for the interest, and trying to calculate it for this owner that calls. A lot of times attorneys use Excel spreadsheets, and if they want to give me that Excel spreadsheet instead of retyping that calculation, I'm fine with that. The other thing it does is it helps our division order analysts find mistakes in their spreadsheets, and it also helps us determine if perhaps we've given the title attorney bad information. Maybe we missed an assignment, maybe we missed a royalty extension that had a royalty increase in it. So if we see those calculations and all the components that make it up, we're able to figure out if we've done our job. And a lot of times, if we find that that's the error, it was just incorrect component, we can correct it and not have to bother the title attorney until it's time to update, and then just bring it to their attention at that time. I need to see the before payout and after payout calculations for the well, showing the unleased mineral owners and then the working interest owners that have chosen to go non-consent. We need that calculation to show us the statutory penalty that we're entitled to for carrying those interests. This is a really big area that continues to be a moving target right now. When we're drilling multiple wells in a unit, sometimes an unleased mineral owner will decide to lease, and we have to decide if we're taking them back to well number 1 or if we're staying with just the current wells. And then you'll also have a partner that might participate in one well and not the other one. So for a spacing unit that has 2 or 3 wells, we could end up having 2 or 3 different division of interests. And you think, well, you just got to treat them like a separate well, but you have that mindset that this is one spacing unit, it should all be the same, but you'll have 1 or 2 things that are different and can make for an interesting day when division order maybe hasn't got all the exceptions, and then we have to work with the title attorneys with a way to figure out how to make that accessible, or either we just do 3 divisions of interest. So it gets to be a little bit of a nightmare sometimes. We'll move on to the comments and requirements. As our mineral and leasehold title continues to be divided and assigned over and over, it's rare that we're ever going to get a mineral title opinion without requirements. Most, average 25 to 50 requirements, and that's why, I sit up here and say I only want to see the ones that require action or the ones that really, have things wrong. If you want to recite for your purposes the things that are right, let's put them in a section that I know that I can kind of skim through, and then, let's leave the requirements for things that really require action. Marketable title can't be achieved if even one of those requirements remains, so that sort of forced us in the industry to rely on something less than marketable title for our purposes. So we strive for what we call defensible title. That being title that is free from such reasonable doubt that a prudent person engaged in the business of ownership, development, and operation of producing oil and gas properties with knowledge of all the facts and their legal bearing would be willing to accept. To accomplish defensible title, we oftentimes rely on documents that aren't in the record. We have to have ways to support our ownership schedules and make us comfortable that we can win in a court case on the evidence of title we have. And we prefer to have recorded documents, but that's just not always what happens. So to me, this means we review the comments and requirements, we evaluate the monetary risk that goes with that particular owner, and then what we would do with his less than perfect title. And then we set about trying to secure enough information, enough evidence, enough recordable documents, hopefully, that will make us feel comfortable and feel like we have defensible title. Because we actually, we can't waive a requirement unless we're comfortable in accepting the monetary risk that goes with it and the fact that title could fail. So let's talk about what makes a useful title comment. First of all, it needs to identify the owner subject to the requirement. It needs to identify what part of the tract or portion of the ownership is subject to or affected by that requirement. That allows us to evaluate the monetary risk. The requirement needs to explain the irregularity, defect, or encumbrance giving rise to the requirement. It needs to include the recording information for the troublesome documents and the time frame of the situation, as well as the age of the defect. All of this has to be in sufficient detail for us to review and know that the title curative we secure is going to be sufficient to resolve the requirement. It also allows us, it gives us the information that we need to evaluate our business risk and determine who we need to contact for that curative. It doesn't do us much good to find out that Joe Smith died in 1950 and we're supposed to contact his heirs, because most likely his heirs are not going to be the people who are leased. So we need to have you follow through and tell us, well, at this point it looks like Joe Smith's interest was leased by so-and-so, and they may be grandkids, or maybe they sold it or whatever, but we need to know the current owner that's affected, because if we can't accomplish that curative by the time that 150 days runs, we're going to need to put somebody in suspense, and we have to have those parties identified so that we can suspend them pending the curative being obtained. Once the requirement has been reviewed and we've looked at our risk, we need to decide what action to take as a company. Do we have to do everything the title attorney suggested? Is it practical in terms of the size and value of the interest? Is it fair to the mineral owner? Are they going to get enough money out of this interest to make all of this worthwhile? What risks do we run in not totally satisfying the entire requirement? Until you're comfortable making those types of decisions, it's okay and probably best to discuss some of that with the title attorney. They're usually a wealth of information and expertise, and they can tell you whether they think it's serious and it absolutely has to be done, or they might be able to help you come up with some sufficient alternatives as well to make everyone happy. And sometimes, you're just going to simply have to suspend people until that curative can be completed so that you can get that defensible title. And they can help you make that decision as well. And then you get that age-old question. Why are you putting me in suspense when you paid me before? Well, you need to determine what is before. Is it the fact that you paid them a lease bonus, or is it the fact that maybe another company paid them? And so it really gives you the opportunity to educate the owner at that point and say, yeah, if it was the lease bonus, we paid you because we felt that you had enough title that once something was cured, we could pay you production. But now it's the time to cure that problem and to, enforce that, the little bit of evidence we thought you had and that was sufficient to pay you that bonus. And you can always ask them if they'd like to give the bonus back pending, but they'll The other thing is, the unfortunate thing is that companies have different risk tolerances, and some companies might pay on little or no evidence, and some companies will be a little stricter. So unfortunately, I think Marathon might be a little bit more conservative than some of the companies out there. At least some people have told us we are, sometimes nicely and sometimes not. But it's unfortunate that we all don't have a set of rules that we can be exactly the same, I suppose. But I find it necessary to at least have something that flows before I can release money. Probates are always a big issue. Do we require a full-blown probate, or is there something less that will satisfy us? I believe it's always necessary to request a probate or inquire if a probate's been completed. Marketable title can never be achieved without a probate. And so, and as attorneys, I think, and land professionals I believe, are in this category too. We all need to strive for good recordable title out there. Our courthouses are being flooded with junk. And so I think our first priority is to see if we can't get the best title out there that we can. So let's at least request a probate. Let's see, what they think about it. There are usually acceptable alternatives if it's a small interest. Sometimes we can use a proof of death and heirship as an acceptable alternative if the circumstances allow. But again, there are stipulations of interest, there are disclaimers, there's deeds from heirs who have questionable interests. But the other thing we need to make sure we remember is that some of these alternatives don't lead to actually transferring title. And although they'll give us defensible title, perhaps, and we can be comfortable that we're paying the right person, we need these people to understand that their title's not being transferred. It's still going to be in Grandpa's name, even if we do that affidavit of heirship. And so I guess I would plead with you that you explain that to people too, because they think because they did an affidavit for one company that their title's transferred, and they don't understand why you might require something more. And if they choose to use the affidavits, and if the oil company's fine with it and they'll pay them, maybe they don't care about anything else. But I always try to explain that the next generation might appreciate if you had gone through the probate. So with that, we'll go into a couple of examples, and then we can get into some discussion on this. First example, John Smith owns 320 acres in a spacing unit. Typical Bakken spacing unit is 1,280 acres. John dies, leaving a widow, Jane, and they have 3 grown children, James, Julie, and Joseph, all children of John and Jane. John had a will that says everything goes to his widow Jane, and if she predeceases him, it would pass to their 3 children. There's been no probate because he owned no other real property or measurable assets. Jane is still alive and requests that I pay her because she's clearly the rightful heir and presents me with a copy of John's will. Well, everything does point to the fact that she is the rightful heir. It doesn't... She's got a will, she's got perhaps a death certificate, she's, his only wife, they are their only children. But we're dealing with a quarter of my spacing unit, and to me that's not a small interest, or, to our company it's not a small interest. And so I feel that, I would feel that the risk would be too great in this situation, and I would request Jane to do a probate. I know she's going to make sufficient funds from this well, so I'm not asking her to dig in her pocket or to go, give the grocery money up to hire one of you to do the probate. But I think it's a good investment for her and her family, and I think it's good for title, and I think it's good for my company. So in this particular incident, I would ask Jane to probate before I would pay her. Probate example 2. The mineral interest in question is 1 mineral acre. And again, it is titled in John Smith's name only. There is an expired oil and gas lease from Jane Smith, a widow. There are 3 current oil and gas leases from James, Julie, and Joseph. And these leases all indicate that they are heirs of John and Jane. We are finding no probates of record for John or Jane. There is an affidavit of heirship for John Smith showing that he was survived by Jane and the 3 children. There's a second affidavit of heirship from Jane showing that she was predeceased by John and survived by the same 3 children. The title requirement says it appears that both John and Jane Smith are deceased and both estates should be probated in North Dakota. And if the heirs are anyone other than James, Julie, and Joseph, that the deed should be sent to them, or they might want to review for additional comment. So what should we do? Well, let's look at the risk on this one. It's 1 mineral acre. Let's say the well is producing 200 barrels a day. Let's say oil is $100 a barrel, and the 3 Smith children have been leased at 16% royalty. If you do the calculation, this interest will it will provide $2.50 per day, or $75 per month, or $900 per year. So given what most of you charge for a probate, how many years will it take the Smiths to pay for 2 probates? And this is assuming everything John has will go to Jane, and then, everything Jane has would go to the 3 kids. So, is that fair? Do we as a company have any real business risk? So say we agree to pay the 3 Smith children on this well, since our risk appears minimal. But say they show up in the next unit with 1 acre, and the next unit, and say we end up with 10 more wells with 1 acre each. Has our risk grown? They might have sufficient funds now to pay for a probate. And this is a simple family situation. 1 spouse, children appear to be the descendants of both spouses. I would most likely put the 3 Smith children in pay, and I would most likely leave them in pay because it is a low business risk of our title failing. But when I start seeing them in the 9th and 10th well, I might send them a letter and say, hey, for your guys' best interests and, to make sure all this has been going right, I would really urge you to do a probate at this time. They might not do it, but, I might do it just in support of having good title out there. And sometimes they want to do it too, because they know then that they're going to have some funds that they're going to want to, and this interest that they're going to want to pass to their children, and so they'll sometimes clean it up. Have you come there? Okay, probate example 3. Same interest, 1 acre, owned by John, but the affidavit of heirship this time was signed by his son James, who's an interested person. The last will and testament of John was attached, showing all goes to Jane and then to the 3 children again. The affidavit of heirship for Jane is also signed by son James, as well, indicating that she survived John and has now died and had those 3 children. But her last will and testament is attached, and it mentions that she has a daughter, Anne, who's not a child of John. When we inquire of James, his response is, well, we didn't really know her, and Dad didn't want her to share in minerals that came from his side of the family. So, what do we do? Do we accept James's word for something that he stands to inherit? So, at this with this fact scenario, I would put the family in suspense until they either probate or we get some sort of disclaimer or quitclaim deed from Anne. And I'd also probably talk to my broker about securing a protective lease from Anne. If they choose to probate, I would want to see verification that they gave notice to Anne, because they've indicated to me that they kind of would like to do things without her, and I know she exists. And if I get a PR deed just to the three of them, I want to be able to accept it, but I want to be able to see that they gave her notice. So I would probably require some of the probate documents be sent for our review. Otherwise, I think my defensible title might have disappeared if I don't do that. I don't know. Are there any questions or comments? Example 4. Same fact pattern, 1 acre, owned by John. Jane has not yet died. She submits an affidavit of heirship with John's last will and testament, showing she gets everything if she survives him, and then to the 3 children. She doesn't want to open the probate because, again, it's a small estate. Everything appears in order. I appear to have defensible title, and I put Jane in pay. So Jane dies 1 year later, and I receive a PR deed from her estate showing all goes to Joseph. Okay, say I don't question this, and I assume that all is legitimate, and I put Joseph in pay. 6 months later, I receive a deed from John's estate distributing that 1 acre to all 3 of the Smith children. Now what do I do? Well, I would put the interest in suspense, and I would start asking some questions. I think I'd end up requiring a stipulation from the 3 kids telling me just who it is that's supposed to be paid here. You know, somebody, Joseph might call up and holler, and I mean, this happens. So, but I wouldn't release it until I had some agreement from the 3 of them, and if that means that they're going to have to take it to court, they're going to have to take it to court. So you can see that a small interest sometimes can, escalate into a pretty worrisome thing. All right, here's another example. Same fact pattern, 1 acre owned by John. Jane survives John. We put Jane in pay because she's provided a good affidavit of heirship to us. She attached the death certificate, the last will and testament. We haven't required probate because we feel we have defensible title. We paid Jane for a few years, and she marries Bill. Upon Jane's death, the 3 children submit an affidavit of heirship indicating Bill is the surviving spouse, and they are the surviving heirs, and they request that the interest be transferred to them. Again, without a probate because it's just 1 mineral acre. There's no will attached to the affidavit for Jane. So what about Bill? Well, I would think that we would need either a quitclaim deed or a disclaimer from Bill, or we'd need a stipulation from him saying that he gets nothing, or perhaps they had a prenuptial agreement that they could provide to us that shows that he's not going to take anything. But somebody is going to have to do something, whether it's Bill or the children. And if it's looking like Bill's not going to back off, we're going to want a protective lease from Bill as well. So what if this scenario happened pre-1975 and the implementation of the Uniform Probate Code? We are seeing in some of these areas some very old titles, so these things do happen. We end up then having to research the laws of intestate succession for that time period, and we have to look at the distribution to a spouse with children that are not descendants of the surviving spouse. And then oftentimes that leads to the question of value for the entire estate of Jane. So again, you can see how 1 mineral acre can kind of blow up into kind of an interesting situation. But, the information has to have some logical flow to it. We, even if it's 1 acre, we can't just say, flip a coin, give it to somebody. I have to tell you one funny story. I was working on some curative in Montana, and it was very old title. It was 3 or 4 generations back, and there were about 12 kids that owned 80 acres. And one grandson was calling from New York, and he would call me every week. Well, when are you going to put us in pay? I leased, you paid me bonus, why aren't you paying me? And I said, well, you know, I really need somebody to help me draw out this family tree so I can see what you're entitled to, because it appears some of your grandfather's brothers and sisters didn't have any kids, so you'll probably get some, you know, a greater share than what you're thinking, but I need to understand this. And as it turned out, you know, 3 or 4 of them had died, and 3 or 4 of them were alive, and 3 or 4 of them had been single, and so it was quite a mess. And, you know, he'd say, yeah, okay, I'll get you something. And then he'd call the next week and say, well, have you put me in pay yet? And, no, I still need that information. He says, well, I have a cousin that knows it better than me. How about if I have her call you? I said, yeah, that'd be great. Have her call me. So she called, and we put some of it together, and he called again. And I said, you know, I've got part of it done, but there's a question, and I think it's your family, and I need to know who this lady and these children are. I can't seem to fit her into the tree anywhere. And there's a long pause at the other end, and he goes, well, when Grandpa died, we found out he had another wife and children and family. And I said, oh, so then you might understand my hesitancy to just release this money. Which family would you like me to pay? And he said, well, of course, our family. So, and I never did find out how that ended, because we happened to sell that prospect before we got done with it. So I gladly boxed it all up with the information I had and passed it on to the next company. So, you know, I don't really know if he ever got paid anything or not, but so it's you know, it's very interesting with families. All right, I'd like to say a couple words about the Dormant Mineral Act. As you learned yesterday, 38-18.101 provides that any mineral interest is, if unused for a period of 20 years, deemed to be abandoned. Well, if you find in your title opinion, or it's brought to your attention, that a surface owner has begun an action to succeed to the mineral ownership noted in that opinion, I think it's really necessary for you to require that all parts of the statute be followed, including the quiet title action. That way you're protected against all the uncertainties of title that could exist with compliance of the Act. You're probably going to need to suspend royalties until those types of things are complete, because it does take some time. It just becomes too big of a risk to pay any part of the proceeds when you see that this is happening. The other thing that you're going to really have to consider is talking to your brokers to get the protective leases, especially if any of the original mineral owners surface and it looks like that succession by the surface owner is in doubt. So you're going to have to make sure that you're leased on both sides of the issue there. Mineral reservations to a third party. As you were also told, the Malloy versus Betcher case from 1983, our Supreme Court held that a reservation can be effective to convey a property interest to a spouse who does not own an interest in the land prior to the deed, but joins in the execution of the deed where it is determined to have been the grantor's intent. So, how do we know what the grantor's intent was? Well, if they're alive, you can certainly ask them, but a lot of times we don't have that luxury. These things are usually 2 and 3 generations old when they come to our title opinion. Sometimes you can tell by the leasing history what appears to be the intent, and you can make assumptions, but if it's anything other than a really small interest, you might not be comfortable with those assumptions. There's the probability that if both spouses are deceased, again, if it's a small interest and the only people that are leased are children that are children of both spouses, and you've got perhaps affidavits of heirships that say that, you may not need probates, and you can probably get by paying on that, evidence. If one of the other had a child, not the child of the spouse, or if there was a second spouse in there anywhere, you're probably going to need disclaimers or probates or stipulations or that type of thing, and again, you're going to have to put that interest in suspense. The Duhigg Rule. Duhigg was developed to deal with the frequent problem of people drafting deeds and attempting to convey more property than they owned. The rule basically states that when full effect cannot be given to the granted interest because of a previously conveyed interest, priority will be given to the granted interest rather than the reserved interest until full effect is given to the granted interest. So it essentially ignores constructive notice and emphasizes to rely on the face of the deed. However, for us, it can create some issues. We'll look at the example of A conveys Blackacre to B, reserving half the minerals. B then conveys Blackacre to C, reserving half the minerals, with no mention of the prior reservation by A. So we know that A owns half the minerals, B owns nothing, and C owns the remaining half the minerals. We also know that if B had stated in that conveyance to C that he only owned half, he might have been able to keep the half he was trying to reserve. So let's take that scenario one step further. B failed to mention A's prior reservation, but company XYZ has leased B and your company has leased C. So who are you going to pay royalties to it, or what are you going to do for curative? Perhaps you want to start by talking to company XYZ and see if they'll release that lease based on what the title says and the law says, and hopefully they'll be reasonable and see that that's the case and release their lease, and you can go about paying. But if they refuse and they talk to B and they say, well, that certainly wasn't the intent, you've got issues. I believe you're not going to have any other choice but to suspend that interest until somebody does some curative. So what if the conveyance from B to C is a couple generations old, and B's heirs have been leasing all along and there's been no activity from C's heirs until the present round of leases? So like in the 50s or the 80s when we had the first round, there's no activity from C, but now all of a sudden some landman, really smart landman, went out there and made the connection and said, C's really the guy who should own this. Well, again, you're going to have to back up and look at the intent, and you're probably going to have to apply the brakes and put the money in suspense until somebody does a stipulation. So again, you can see that it can become a really interesting situation. So in conclusion, you can see that families and just the thrill of having a lease and the potential of receiving income can create some really interesting scenarios. But please realize that those of you who write our opinions, somebody on the other end has to read them and use them. So make sure they're usable. Make sure we understand what you're trying to say to us. Those of you who are reading them, you have an opportunity to talk to your title attorney, to talk to the public, to make sure that those comments and requirements make sense so that you pay the right people, and that we get good law out there. We'd all love to have marketable title, but it appears to be a rare commodity anymore, and this defensible title may be all that we can strive for. So anything any of you can do to assist us, we greatly appreciate it. We need you to follow the title standards. We need you to follow the laws of descent and distribution. We need you to follow the probate laws, the distribution of domestic realty, and all the real property laws. Title has to flow legally. We're always opening, as a company, we're always open to listening to your suggestions, but you do have to realize that we are the ones paying the money, and so we're probably going to have the final word. But we want to hear what you have to say. We don't sit out there trying to determine, keep your client's money, and we really want to get it paid to the right people, but it has to make sense too. So I leave you with patience plus cooperation with a dose of reasonable curative makes happy owners and happy companies. I want to thank you for your time and attention. I want to thank my son Jordan for his technical support. I want to thank the Law Review for putting this on and providing an opportunity to get together and to get so many CLEs taken care of. I think it's great that Steptoe and Johnson has stepped up to help the Law Review. I hope I was able to give you some idea of what we face from the inside of the companies and the questions that we need to ask and why we ask them. And again, if you guys have any questions about any of my scenarios, I guess we've got a little bit of time. We can talk about them now, and if anyone wants to talk later, I'll be around as well. So thank you.
I don't do a lot of work in the oils area, but I'm kind of curious from your point of view. Are two questions. What are you paying for your title work, and maybe the average? I know they're all over the place. And how are you using legal services? Are you using one firm exclusively, or do you use a number of firms?
We use a number of firms just because at one time our company had 8 drilling rigs, and there was no way that one firm could stay in front of it. We used multiple abstract companies. We used multiple firms. We probably have close to a dozen firms that we use. We try to use our North Dakota firms because we think that they're most familiar with North Dakota law, but that really, when we started this project, there were very few North Dakota firms that were doing it, and so we have branched out to firms in other states that have North Dakota lawyers, and that's proved to be a very good relationship and successful as well. We go back to those firms usually that have done our base opinion to do the updated opinions. I would say hourly fees range anywhere from $200 to $300. We do make some of that known to our title attorneys so that they know if they're pricing themselves out of our work, because title attorney, or our title budget is being scrutinized as well as the drilling costs, and so we let our attorneys know that as well. Most of them give us the best service that they can, and if they don't, I guess we don't perhaps use them, the next time. There's been very few in that category, but most of them are very willing to do anything they can to make it work.
What's the average bill for
the average, it depends on how many pages of documents I give them. I've submitted 4 banker's boxes to an attorney to do an opinion before, and that bill was, considerably higher. We've got tribal issues on the reservation, and they have to make a trip to Aberdeen to look at the Indian leases as well, so that adds to it. But, most opinions, an average opinion is probably in the $20,000 range. We've had some go, double that with Indian law and with fractionated interest. So I mean, it can go higher. Is that?
I have a question. Could you describe what a protective lease is and how it works and who it's protecting?
I guess it's something that we call, it's not a legal term, I don't think. It's like in my scenario, all of a sudden we learned that there might be another heir out there, this Anne, and so we would want to quickly get her leased as well, because otherwise we would have a potential interest out there that wasn't leased, so we call it a protective lease. We don't know if she's going to end up with an interest, but she has a potential to, so we want to make sure she's covered in the event. So we're willing to pay that bonus to get her tied up. Anything else?
No, if there are no further questions, then we'll go ahead and close up.